Hey everybody, welcome to All Rise Legal Network. So what we're going to be doing every week now is we're going to be watching these guys over here do their weekly tenant landlord stuff. Sorry, I forgot what video I was talking about. So I'll have every week we'll have Judge Simpson's weekly landlord. It's generally a train wreck. Today's wasn't too bad. There's going to be one where we have some legal students coming from the University of Michigan, and it's just really interesting on what these guys' defense is to help this tenant out. This has a huge history. I might just do a whole video of all the hearings with this specific tenant. But anyways, it's fun to watch for me at least. This is for legal nerds only, or specifically, or mostly. So all the law nerds definitely need to assemble. We're going to have a great time. Please like and subscribe if you enjoy, or just like and subscribe now. That would be dope. So anyway, thanks guys. Enjoy the ride, and we're going to start the video now. Whoa, okay, I'll see you guys later.
Court does call the case of Evergreen Apartments versus Bridget Taylor.
Your Honor, Jillian Aiken, please.
Oh boy. Here we go. Hello, Miss Taylor.
How are you?
I'm very good. I think your counsel's here as soon as I give him permission, if I do.
Okay.
Jude Rich requesting permission to appear on behalf of defendant pursuant to Michigan Court Rule 8.120, supervised by David Santacroce.
I'm Semi-Day, also requesting permission under the CR.
Good morning, Your Honor.
Good morning, Mr. Santacroce. Yes, sir. Have I seen you two before?
No.
I didn't think so. Where are you from?
I'm from New York.
Oh, sorry.
Fair enough.
What part of New York?
I grew up on Long Island.
Yeah, that's even worse. All right. And you?
I grew up in Michigan.
Yes. What part?
Midland, Michigan.
Okay. All right. Very good. Where'd you go to undergrad?
I went to Northeastern University in Boston.
I know where it is. Yeah. Okay. And you?
Michigan State.
No, it's okay. We just have to talk slow. All right. I'm sure they told you I'm a Maryland terrapin and I don't really like Spartans, but we'll work through this. Permission to practice is granted to both of you. Thank you. Welcome. All right. What are we doing on this case?
All right.
Adjourned to matter of February 2nd, 2024 at 11 a.m. Anything else that the defense needs?
That's it, Your Honor. Thank you.
Sure. Are you sure?
I believe so, yes.
You believe so, so you're not sure.
I'm sure. There's no
Okay.
evidence.
I'm sorry. I don't mean to mess with you. I probably do it. All right. Thank you. And I'm sorry about the Spartan joke.
Okay. I've heard it a lot.
Have you?
You is not very supportive of my undergrad.
And neither are the terrapins, because can you spell terrapin real quick? No, of course not. It's longer than 7 letters and you're a Spartan. Okay. Anyway.
APIN. Is that right?
TERR APIN. Yes, you got it.
Every now and
But he's not a Spartan, so I knew he'd get it. All right.
Thank you.
Guys, good meeting you.
Thank you, Judge.
Thank you, Ms. Taylor. Court does call the case of Evergreen versus Desiree France. Court calls the case Universal Realty Management versus Cassandra Green.
Carol Barton appearing on behalf of the plaintiff, Your Honor.
Jill Bauer appearing on behalf of the
All right. Is Ms. Green present? Or?
Oh, Your Honor, she has pneumonia.
Okay. All right. Where are we on this one, folks?
Termination of tenancy, month to month, proper notice, notice from section 8, they're terminating due to the tenant's actions, asking for a possession judgment, Your Honor.
Your Honor, I was handed a termination notice a few minutes ago dated December 1st, 2023, saying that due to program violation by tenant that the contract would be terminated on December 31st. I think this was issued in error because we have not received a final decision on the ALJ hearing that I conducted. And then I looked at the letter that was provided to me by plaintiff, and the HAP contract did pay in January. And then I was on the phone with CMA.
Hold on a second. Your notice, a 30-day notice?
It says contract termination notice, Your Honor, but I think.
Well, what is it from? Who's it from?
It's from MISHDA, Housing Choice Voucher Program.
Okay.
It says that it was terminated due to a program violation by the tenant, but that flies in the face of conversations that I had with MISHDA and CMA yesterday. And also it flies in the face of the fact that the HAP contract paid January's rent. So I think this was issued in error somehow, and I want to investigate it.
Yeah, but hold on. Where'd you receive that from? You said,
From plaintiff's counsel, just handed it to me.
so plaintiff's counsel received that from MISHDA, and they provided you a copy.
Yes.
Okay.
But I also, I'm sorry, Your Honor.
No, go ahead.
I also filed an answer yesterday where we have established a defense of retaliation for conditions and repairs issues.
Whether you've established it or not may be an issue, but I see the answer. Ms. Martin?
You want a response? I'm sure. Your Honor, this is a month-to-month tenancy. A lot of the things in the answer are totally irrelevant. The fact that he allowed a month-to-month tenancy after the lease ended in end of April, she said they waited 7 months. The woman hasn't made a payment since October 3rd. She's always been behind. Late fees weren't charged until November. All those other months she was behind. And this was an inspection deficiency notice. It's an annual inspection. They've had an annual inspection. They've been there multiple years. And now all of a sudden, when we ask for a termination of tenancy on a month-to-month tenancy, they're claiming the place isn't habitable. Move. Either tenant could have given a 30-day notice to the landlord. And this is one where they attempted to do an inspection and the tenant wouldn't allow them access, refused to allow the Section 8 people to come in. And so they were denied access to the unit. And the other thing was to replace a broken window, which shows on the landlord. I have a copy of this. And the landlord did, in fact, replace the broken window. We're simply asking for a possession judgment. At this point, we'll waive even any rent, etc. He wants possession of his property.
Your Honor, I dispute the way that the facts have been presented.
Of course you do. That's why I'm here.
The lease ended in April and it continued as month to month. My client's been there for 7 years. And she's had this MISHDA decision pending. And I have texts. I didn't attach them to my answer because I had a short amount of time to get, an answer to the court. But I have seen texts where the landlord texted my client that her rent as of October 1st was at 0, that she was paid up, but then that's not reflected on the ledger that I was provided. And he was happy for her to continue in the unit without a lease, with a month-to-month tenancy until she made claims that there was mold in the unit and she was worried that it was going to impact her grandchildren. And then 6 days later, a termination of tenancy was filed, and she had made complaints about leaky pipes, leaking dishwasher, leaking sink, and the windows not being sufficient and needed to be replaced within the 2 months before this notice to quit was filed.
Okay, but did she call for an inspection at all?
The inspection, Section 8 attempted to inspect and she wouldn't let him in.
That's not accurate, Your Honor. In December, there was a meeting that the inspection was supposed to take place, and she was in the hospital. Then it was supposed to take place on January 18th, and she went into the hospital that day, but her adult children were at the residence waiting for the inspection. I have text back this up. The landlord called Section 8 and canceled the inspection.
Well, what do you have a proof of that?
That the landlord called and canceled the inspection?
Yeah.
Well, CMA told me that yesterday on my phone conference, so I would subpoena them to testify about how that happened. The inspection is now scheduled for February 1st.
May I speak, Your Honor?
Go ahead.
Anyway.
Doesn't stop anybody. Yeah.
My client is here, and he was told he waited for that inspection and was told that they were canceling it. Section 8 was canceling it. And at this point, it doesn't matter if there's another inspection. It's a termination of tenancy. They would not be an occupant, and he plans on selling the property. So at this point, it's not relevant if there's some future inspection. This is a termination of tenancy.
I understand it's a future inspection, but if their claim is, but I don't have a whole lot other than words.
May I approach you with a copy of this?
What is that?
This is the inspection deficiency notice by which the issue was to allow.
Is that the same thing that you provided?
No, she's looking at something else. She's looking at the letter that says it terminated the
I would like to
contract.
see that before.
This is the same
Okay.
one. I have one. I have multiple copies. Would you like to see this, Your Honor?
What is that? That's
This is the same one.
Okay, well, hold on. Let's look at it. There are reasons why I shouldn't see it.
I don't have a problem with you seeing it, Your Honor, but I do have an explanation for it.
Okay, of course. Whose writing is that?
That's my writing, Your Honor. I have a copy without.
Okay,
That's my writing at the top.
Okay, what's the explanation?
Your Honor, Ms. Green has a condition where she's frequently having strokes and seizures and then being hospitalized, and that she has periods of cognitive recovery after this happened. So the issue with the inspection in December is that she was ill. But then, and I strongly...
But I thought that was the one that the landlord canceled.
That was on January 18th. And CMA told me yesterday on the phone with Mishta that the landlord called and canceled that inspection, said that Ms. Green was in the hospital. She was on her way to the hospital, but her adult children, I have texts from her saying my kids have been waiting all day and nobody showed up. And CMA said that they canceled that inspection because the landlord told them that Ms. Green was in the hospital. That's what they told me on the phone yesterday. Because I asked why we didn't conduct the inspection on that day.
Okay.
So my client says that it's Section 8 that called because of the weather. He was available, but on whatever date, and there is nothing, he did not cancel it. So my problem, Your Honor, is all of this is not relevant to a termination of tenancy.
I've heard you now for the last 5 times. I get that.
I'm having trouble.
I understand your position. And I guess I'm trying to understand from the defendant's perspective how all of this. So if you're trying to claim that there's some retaliation, right? It seems to me that you would have a long way to go because obviously there's a program violation that terminated the voucher, right? Terminated the assistance.
I don't think it did, Your Honor, because they paid in January. Mishta paid. That's what I'm saying. I think that this is somehow issued in error. because Mishta has continued, Mishta.
Yeah, but Mr. They're gonna operate on a 30-day timeframe, right? From my recollection in the past. So I almost would expect that the January payment would be made even if the tenant defaulted, so as not to leave the landlord out, because they have to give a certain notice to the landlord that they're not paying.
I'm sorry, I didn't mean to cut you off.
No, go ahead.
They gave a 30-day notice and they said that the contract would be terminated effective 12/31.
Do you know anything about that payment?
It was a direct deposit, Your Honor. There was an outstanding balance, and it was credited to the outstanding balance, just like any payment would be made to any outstanding balance. I can provide you with a copy of the ledger.
Right, but
The ledger also has a lot of charges that we think are.
We're not asking for a money judgment.
I know you're not. However, I'm going to get to another point. If the notice I have, the notice to terminate tenancy, indicates that she was to move by December 18th of 2023. So whether it be mistress payment or the tenant's payment, let me just strike that for a moment and ask this one question. Does the mistress payment pay the entire rent?
No, Your Honor, and I do have some.
Okay, well, somebody just answer my question. I'll let you guys talk. How much does the tenant owe?
Well, right now, the rent has been calculated for Ms. Green to pay.
Why can't I just get a simple, how much is the tenant's portion?
Right now, it's calculated at 962, but it's under review because she lost her income and they haven't reached out to me.
Okay. Let me try it again. In December, what is the tenant's portion?
960.
Okay, so how much was paid by Miss Jeff or paid by the voucher?
On January 5th, there was a direct deposit of $704 from the ledger, which did not even cover the prior 2 months.
I hear you. Here's what I'm going to do. If your answer to my question doesn't directly answer my question, all of the other superfluous stuff, I'm not paying attention to. All right? I'm asking questions for a reason. So December paid December, that same amount was paid. January, a certain amount was paid, right? So my question, and accepted by the landlord, right? So my question is, why, given the notice that I have, do I not potentially have a park forest problem more than anything? Wow, silence. I should have
Do you
asked.
want me to answer this, or are you waiting for someone? I understand what you're asking. Any payments, even with the payments, it would go to arrears before it's paid. That's true of any landlord case where you have somebody making payment. You can't come in and say, I'm going to pay February rent, and you owe all this money in the back. And this was, a surprise. And there was a huge outstanding balance as of that date.
First of all, Your Honor, we dispute that there's a huge outstanding balance. And to be honest with the court,
Of course you do.
I would need a moment to consult on the park forest or
Park forest.
that
Well,
question.
there may be a simple answer to it, because what Ms. Barton is indicating is that there's a huge back balance, which means that whatever was paid was not paid beyond the expiration of the notice. But what you're claiming to me is that there were payments that were made. You're disputing their balance. But I don't know to what extent, and I realize rent is not the issue here, but to the I don't know to what extent you're disputing the balance. Go ahead.
Your Honor, I've submitted a reasonable accommodation request that the rent be recalculated back to at least December 1st because Ms. Green lost her income November 27th. Her daughter had lost her income in October, and the rent should have been recalculated because her disability wasn't able to get a new form that they're requiring.
Okay, but Ms. Mauer, that doesn't answer my question. At some point, let's say it's recalculated and her portion is 0 for December and January. Let's just, for the sake of argument, let's just say that. Prior to that point in time, was there money owed?
Your Honor, if there was any money owed, it was a portion of November's rent, and I say that because Ms. Green had been paying more than she was supposed to. And then she was caught up in October. Also, water bills have been added to the meter that she paid directly to the water company. So I think the amount that she actually owed is small once the rent is recalculated.
Okay, but
Not asking for money judgment.
now for the fourth time I ever heard you whisper. But you, Ms. Bauer, can't tell me that the payment the landlord received in December would have paid beyond or would have paid to the end of December.
I'm sorry, Your Honor, I don't understand your question. The payment that the landlord received from
Miss Jeff, because I don't think he's received any other payments from her.
That's correct. October 3rd was the last payment from her.
Heard you again.
Well,
No, I get it. You're making a record, but I can still hear. I'm old, but not that old. So what I'm asking is this. At some point, you're saying her rent 0, right?
I think that it will be 0 very soon. Because I've done a request for reasonable accommodation, but it's not 0 today. But this isn't a non-payment of rent case, Your Honor.
I apologize, Your Honor.
I know. I get it. But if this were a non-payment of rent case, I wouldn't be bringing up Park Forest because it wouldn't matter. I'm bringing up Park Forest only because you're claiming that she paid or would pay or whatever. I am asking, at what point does the rent 0 out so that I can even get to the beginning of a Park Forest analysis? But nobody seems to be able to answer that for me.
I have a copy of the ledger if you'd like to see it, Your Honor. And then you can answer that question without them answering it.
I don't think the ledger is accurate.
Okay. Then if the ledger's not. Okay, let's try it this way. December or January, did your client make any payments?
No, Your Honor.
Okay.
I have one more piece of information that I haven't told you yet, Your Honor.
Oh, Joy, go ahead.
Mishna did confirm that Ms. Green should be provided with a moving packet, and we're supposed to get it today.
Okay. So while I've sat up here for the past 20 minutes, she's moving?
They've approved for that process to start, but she doesn't have the packet yet, and it's a process.
Okay, I get that. But she's moving.
Yes. I mean, yes, Your Honor.
Okay. Then it seems to me that the party could sit there and talk to each other about a move-out date. Why can't we do that?
I've asked.
I did not feel that plaintiff was flexible about more than 10 days based on previous conversations.
Oh, dear God.
Shouldn't ask me.
Okay, yeah, so why don't, can I put both of you into a room and you guys see if you can work that out?
Gladly, Your Honor.
Okay, so you guys go out, use one of those conference rooms. Alan, keep a watch on the door. Don't let him out. You guys, what?
Can I just say, Your Honor, I am not trying to frustrate the court.
No, I am not frustrated. This is my normal state.
But I'm still learning, and I didn't realize that that was the thing I should have led with, is all I'm
That you should have led with what?
that she was going to be given a moving camera. I didn't realize that's what I should have.
Oh, yeah, you should have led with that probably about an hour ago.
I'm learning.
All right. Okay, you guys go in there and you guys figure it out.
Thank you.
You're welcome.
Go back.
Oh, quit threatening me. I am so afraid to call the next case. Court. Calvin Johnson versus Denitra Walker. They're on Zoom.
Good morning, Your Honor. Matthew Weaver on behalf of the plaintiff, Calvin Johnson.
Good morning, Your Honor. My name is Leon Boykins, and I'm a student attorney with Michigan Law Civil Criminal Litigation Clinic, requesting permission to practice under Rule 8.120, representing Ms. Denitra Walker, who is on Zoom, as well as my partner, Hank Graham, and supervising attorney.
I need you to step back from your mic a little bit.
Sure. I'm using headphones, so if I talk softer, is that better?
You're really blurry to me. I don't know why.
I've taken off the headphones. Is that better?
That is better. Thank you.
Of course.
Okay, you're requesting the permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Ms. Sullen. Is that correct?
That is correct.
You're doing that on behalf of yourself and your partner?
Also correct.
Okay. Have you guys been before me before, or you guys new?
Last week we were here.
Oh, must have been memorable. All right. Permission to practice is granted. Go ahead.
Okay, thank you. So as you probably know, since our last hearing, we have filed our answer with counterclaims and limited defenses. So we are requesting limited discovery as it relates to the contract to buy, which includes communication between the parties. And
counsel again, can you just back up from your whatever device you're on?
Sure,
because
I think
you really are coming through to me very, very like you're right on the microphone.
Okay, I'll use my inside voice.
All right, go ahead, give it another shot.
So since our last hearing, we have filed our answer with counterclaims and limited defenses and are requesting limited discovery as it relates to the contract to buy. It's going to take us some time to get records of the Sarah conduct as well as the alleged DTE payment from DTE to Johnson to make required kitchen repairs. And we are happy to work this out, but as of yet have not come to a fair agreement.
Okay, if I may, Your Honor, this is, I believe, the fourth hearing on this case. This is a termination case. With all respect to counsel, and we had a phone conference yesterday. I believe all of their affirmative defenses and et cetera filed in their answer are as though this is a rent case. It's not. It's a termination case. Your Honor, at the last hearing, gave them until yesterday to file an answer. Your Honor did not give them leave to file a counter complaint, which they technically haven't, but this is titled including counterclaims, which counsel asks to be heard, and that's what he's asking for discovery for. So my client's position is that he would object to any further. We consented to an extended initial adjournment. We consented to the second adjournment. At that point, Your Honor said once more. Your Honor gave them one more. We objected then to their third adjournment to today's date. And Your Honor gave them until yesterday to file an answer, again, not a counter claim or counter complaint or whatever we want to call that. It's a simple termination, Your Honor. The defendant has not made any payments in a year. The issue, really, I think what Your Honor kind of drilled down to at the last hearing was she's saying that there's I believe it's a lease with an option to buy. My client is saying no such written document exists. The clinic has represented her at least since August. I wasn't involved back then. I'm not sure the exact dates. I said, fine, guys, if there's a written agreement, by all means, please show it to me. My client's telling me there isn't one. So that hasn't been produced. And my client just wants to move forward with, it's a straightforward termination of tenancy.
Well, with reference to the first thing you said, if they wish to file their counterclaims, I mean, I'm not speaking as to the merits. I mean, I think they're entitled to do so. So, the real question, though, from the court standpoint, and counsel should be aware, I had these parties before me, I don't know how many times, trying this same thing over and over. And somebody can't seem to get it right, but that's okay. That's why I know that there is an issue regarding, or at some point there was an issue, at least alleged, regarding the sale of the premises. Is there a document that evidences that?
Plaintiff says no, Your Honor.
And from our side, if I may, we are just saying that we need more time to investigate. And probably as you remember, this alleged contract, the sale has come up in court before, which Mr. Johnson did admit that it does exist, or at least they discussed it.
Well, what I can say is, respectfully to address the court's comments, my understanding is this is the first time that this has been brought as a termination as opposed to a failure to pay rent. Again,
This is the first termination case?
That's my understanding, Your Honor. Again, I was not involved.
I got you.
Also, and hey, I could be sitting here saying this is the first time I'm involved, so of course it's the first time it's going to go right. But be that as it may, this has been going on for this amount of time. My client said that there was a verbal agreement, that there was conversation about that with Miss Walker's husband, who unfortunately passed away about a year ago. So if there was an agreement, at the very least, circumstances has changed. Also, for the past year, it's not like Miss Walker has gone to this or any other court to try and enforce this agreement if the idea is that my client is not is not in compliance with the agreement. My client said, he says there's no written agreement, Your Honor. I have not seen one. Counsel hasn't given me one. Again, they've had at least until August. They could have sent it to me when I sent the notice. They could have sent it to me at the first hearing, second hearing, third hearing, etc. I've been begging for it. I got nothing. In order to have discovery and move forward and for this court to entertain that, I know this court is well aware there has to be some sort of offer of proof. And quite frankly, there just isn't one.
Stepping away from that for a minute, as I'm looking at this answer, is it the claim of the defendant that you paid rent or whatever would be what might constitute rent, that she's paid in full?
No, not that she is paid in full, Your Honor, but I think there is some discrepancy as to what that balance would even be, especially since I believe a year or so ago, it came up that the payments were being made when the other side was still receiving payments from the SARA program. So, we from our end, we also
the SARA program the Sarah program would have just paid in 2001 and part of 2022 before the Sarah program disappeared.
Mhm.
So I'm saying from the time of that payment, and that would have usually been just paying back rent plus maybe some future rent up to a certain point, usually not more than 3 months from the time of that payment. So my question is, and if I just skip all of 2022 and just say for 2023, is there a claim that all the rent's been paid for 2023 or what might constitute rent?
No, that is not what we're claiming, but it's also unclear based on the status of the lease, like what the rent would even be, especially since the amount that Ms. Walker was paying was the amount that corresponds to the alleged rent to buy agreement. So we don't even know, that's why we're asking for limited discovery, just to get more information as to what the parties actually.
Well, what's your client claiming the rent is? I mean, I don't know, why would I be giving discovery regarding rent if your client can't tell me what the rent is? That was a question.
Your Honor, I just want to briefly state that the rent, we are not claiming that she has paid the rent in full, but our further claim involving the conditions, we believe is sufficient for an abatement of what has not been paid.
Your Honor, I saw I believe it was the hearing before last, so I am not trying to make that mistake, but I do believe I have to point out at this point, rent is not an issue in this case. This is a termination.
Sir, I get what the case is.
I understand.
Somehow, quite frankly, your client has messed this up, and I'm surprised he didn't tell you about the previous hearings. I think he's been here 3 or 4 times before. Many times I've had to throw it out. So don't try to tell me what the case is about. I've been doing this a minute. I'm asking these questions for a very specific purpose. Counsel, for the defendant, tell me what makes you believe that the court granting you discovery in this case is somehow going to uncover some option to purchase.
Your Honor, our client has specifically stated that there is a document regarding the option to purchase. I believe that if we conducted a discovery
where is that document?
I believe if we recover we believe the plaintiff has it, and if we could
you think the plaintiff has it? They just told me they don't have it.
We believe that if we could engage in a form of discovery of the communications between the plaintiff and the defendant, we may be able to find it.
Respectfully, Your Honor, my client will testify right now.
Counsel, I don't mind granting discovery where I can see that it's going to lead to some practical result. I mean, is it your allegation that for whatever reason that the plaintiff is hiding this document? Because if that's before you answer that, if that's the allegation you're making, I need you to understand that's a serious allegation.
We believe he needs to be ordered to produce.
Pardon?
We're arguing that he needs to be ordered to produce said document, or
Why? How am I going to order a document that they're claiming doesn't exist? well, hold on, counsel. I don't mind giving you that order.
Understood.
But then if you're asking for something that's frivolous or does not exist, then I'm going to let you know. I'm going to be sanctioning.
Understood.
Because I've got to have some good faith belief that that exists prior to me ordering somebody to do something.
No, I
And I
understand.
haven't heard it yet.
Understood. And I think I'm going off of a lot of the facts from that February 2023 case, where it was admitted that the defendant and the plaintiff had not seen one another in person, but there was, like, on the record, an admission by Mr. Johnson that the agreement did exist. So we think there has to be some sort of written.
You have that? You have that on record?
We do. There is a video of the trial, sir.
Of a written agreement.
We do not have that's the point of the limited discovery, is that if the two parties were not communicating with each other in person, there has to be some sort of written communication about this alleged contract to buy.
Or someone's mistaken or confused and there is no writing, but they thought there was. That's another perfectly rational explanation for that.
Yes, I understand, but isn't that the point of limited discovery, so we can get to the bottom of the question?
We can have this esoteric conversation. I don't need to be a part of it. Here's what I'm going to do, folks. Have you provided to plaintiff's counsel at all that copy or that portion of either the hearing or the transcript that indicates that his client admitted there was some agreement?
No, Your Honor.
We can provide it.
I asked
you haven't.
We have not.
If you
yet.
haven't provided it, why not? He's claiming that it doesn't exist. You're saying, well, your client admitted it. Why wouldn't you just show him that here's what your client said? And can we have a copy? I don't understand why I need to be involved in this.
With all due respect, Your Honor, I very specifically requested that yesterday afternoon.
I don't care. I don't care.
I would like to put that on the record.
I'm not asking you.
We have discussed it with opposing counsel. It is available on YouTube. We asked him if he had seen it. He told us he had not.
Give me final settlement conference day. Just give me a Tuesday.
And we will send it today.
6 or February 13th.
February what?
6 or the 13th.
All right, folks, here's what I'm going to do. You get that information to them, tell them this is where we're getting it from, what necessitates our request. I mean, it's really simple, folks. This doesn't have to be a hide the ball game. So I'm setting this for final settlement conference. Parties need to appear in person February 13th, 2024, 9 a.m. And I'm just going to walk it through with you guys in person. I want the parties there. All parties must be present with the authority to settle the case.
I'm sorry, Your Honor. I didn't hear the time.
9 a.m. sharp.
Thank you, Your Honor.
In person.
May I respectfully request, Your Honor, that the defendant have to post a bond or pay rent into escrow, as this will be the 5th hearing on this.
I get the number of hearings, counsel. I also sat through 10 hearings with your client who didn't know what he was doing. So the fact that I'm at 5 now doesn't matter to me. I will take your request for escrow, which would become effective February 1st. I will deal with that on the 13th. Not dealing with it today. I'm done. We'll see you on the 13th.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.